Okay, let my people go, family. I've been gone for a minute. This is a live session dealing with reparations, taking our country back, as well as taking our prisoners of war back from these human traffickers. Okay, see at the bottom where it's talking about reparations. Everybody's talking about reparations. I'm talking about it, and I'm doing it. This is who's doing it. I want you to hear this and see this case, what's going on. I don't know if you can see all of it. But I'm going to let you read it. So that way, it'll be for you to understand. Then I'm going to play this last court recording I had on the 5th of July. Total scam. Tore their asses up too. This is like 5 pages. Believe me, this case is on board. Coming to get all of our prisoners. If you're in foreclosure, if you're in foreclosure, this case is here to stop it. If you got these fake banks telling you need to pay every month, this case is about that. Then I want you to read this because it's highly important that you see what this court is trying to do. Going slow so that way you can get it all in, because some people complain that they can't read it, and you will be able to go over it as I give it to you. This is like 5 pages. Haven't been online because I've been in court and helping other people. So excuse me, my Facebook family, if I have not been around. But I'm here. We're in trial. This is a class action to get all of our prisoners of war. So if you've been to prison, you have money coming to you. Everybody has money coming to them from this class action case because of what they've done to the people of hiding this will to the promised land. I want y'all to really, really know that I'm fighting for you. Every day I fight so hard for you. I'm not done with these people. Then I'm going to play this hearing in a minute. It's really, really crucial that you hear this, how I crushed them. Get it all in at one shot. Then if you can, focus it or get it in your computer, please do. Reparations. Everybody's talking about it. It's right here. King Abdul Muminel's done it for you. You ain't got to be around here talking about how people got to go. Well, ADOS, it's a bit different here. This is where it's at. We're in Morocco. They know it, and they're trying to keep us away from our people and make money off of us every day by sending us to their fake prisons to rob us of our royalty and all of our currency or money. So please take a look at that. And I'm going to play this for you because this is what's really going on with the case. You have to really listen.
This is the matter of Joseph Stanley Figgett, also known as King Abdul Mumin et al., under clause number 19-2-10040-1 with a Seattle designation. This matter is here on motions to dismiss filed by the defendants, David Tracy and King County.
Boy, Doc Rhodes.
And before we get underway, I'll have the parties introduce themselves from the record, starting
You already know.
to your left.
Greatest.
Good morning, Your Honor. Samantha Tanner from the King County Prosecutor's Office, Civil Division, on behalf of King County Superior Court, and retired Judge Barber.
Hey, good morning, Your Honor. For the record, Alexander Subway, appearing on behalf of Mr. Tracy and Ms. Barr.
I'm sorry, the correct pronunciation of your last name?
Subway. So think Martini, but Subway.
Okay. And sir?
For the record, King Abdul Mumin et al. For the record, I'd like to object to the whole proceeding. I believe you have the work. I didn't get a chance to know if you got the working papers or anything like that.
Well, what I received coming in were the motions from both of the defendants, and then I received your responses to both of their proceedings that were filed on July 3rd. Did y'all receive those as well?
Yes,
sir. Yes, sir.
All right, it's a defense motion, so procedurally this will be how it works. They have filed the motion, so they'll have a chance to present their arguments first. Then you will have a chance to respond, and then after your response, since it's their motion, they'll have a chance to reply. Or in time-wise, got another matter is 11:30. Is that correct, Ms. Bailey? Okay, 11:15. Okay. All right. The rights, Rod, Ms.
So I'm objecting to the whole proceeding. I believe you have my understanding. So what court I belong to? I don't belong in the court. My court is Moroccan court and Article 3 court. And this is an inferior court, and she brought this action based upon her claim of a motion to dismiss on my treaty rights.
But and that's what I understand this whole proceeding is well. What this whole matter is about is that your allegation or belief is that this court, King County Superior Court, Department 43, whatever Judge
Framed.
Department was, do not have jurisdiction over you.
It's a 58,
So
almost
I know that
58-year-old
coming in,
picture.
That's not what the issue was at all.
Well,
There's quite a few issues at the time in which you're listening to. Obviously, you're already biased by her opinions on her paper. That's not what I said.
well,
And I have a class action. That's what I have going on. And I raised those issues up with her based upon I had the same situation like I have right now with the flag. I'm demanding that you honor the oath of office in which you had to move to our peace treaty. Are you familiar with that?
let me tell you, what I have is your complaint. Your complaint here, there are two counts that are set forth. One is negative. Defendant Barbara failed to perform her duties according to the Moorish-American Treaty of Peace and Friendship of 1787 and the U.S. Constitution, Article 6, which led to plaintiff being damaged and plaintiff sustained damages from this court order to lose his property and land. That's count one. Count two, I see unfair business practices, RCW 19.86. Defendants David P. Tracy, law offices of David P. Tracy and Heather Winslow Barr, has violated the Treaty of Peace and Friendship of 1787 and the U.S. Constitution to take real property and land, which the Article 14 of the Treaty of Peace and Friendship of 1787 and the U.S. Constitution article forbids, and plaintiff sustained damages from a fraudulent court order to make plaintiff homeless. So, when you know, it seems as if you've had some experience litigating.
I've been
Let me finish here and then I'll give you a chance. What I start with is a complaint that someone files. And so I see the two claims that you set forth here, and they appear to this court to be that you don't see this court, King County Superior Court, or any Superior Court as having jurisdiction over you based on your Moorish background.
No, based upon the fact that we have a peace review, even though she called herself counsel, she's involved in the peace review as well. And so she's a U.S. citizen, I'm a Moor. Are you familiar with the U.S. Constitution and the Treaty of Peace and Friendship?
I'm familiar with the U.S. Constitution. This is the first exposure I've had to the Treaty of Peace and Friendship.
Okay, you're not competent to hear this case.
I'm competent to hear this
No,
case.
I'm
So
not-
if you want to argue,
I'm
I
not
need,
competent.
sir,
Yes,
I
sir.
need to go by my procedures here, the procedures here in the court. I'm going to give you a chance to make your argument, whatever your argument will be. But they filed their motions,
Oh,
so they get a chance to go first, and then you can respond.
All I'm saying to you is that they don't have opportunity to make a motion, period, because of the standards that we have to meet before they can even talk.
Well,
Now, let me finish talking.
I'll give you a shot.
Yeah, because what she's doing right now is treason. My charges are treason. You have my paperwork for the United States District Court, correct?
I do not have.
Well, have you
I
taken
don't
a
feel
motion?
I reviewed.
My motion came to you through email. You have that documentation. Okay. I gave this as exhibits, the documentation that went to the U.S. District Court talking about this, the very same matter.
I did see that to Judge Martinez for the declaration.
Okay. So therefore, Judge Martinez, and all the information I'm giving you, tell me you're not qualified to hear this case because of the treaty itself, which requires you to be obedient to, because of the Sixth Amendment requires you to be bound by that oath of office. Okay, are you familiar with that?
I'm familiar with
Okay.
this. I'm ready to proceed to this.
No, I'm not ready.
I'm going to give you a chance to make your argument, sir.
Okay.
I need to go by my procedure. I've got another hearing here at 11:15.
Again.
So I'm going to let, and I understand that you say neither of these attorneys should even have a chance to
I'm in
present
my
the
court, sir. I'm in my court, not your court. I'm in the kingdom of Morocco. You're on my land. This is the problem we have here. You're used to doing it your way, and I know how it's supposed to go. By law. Not from statutes and codes of what you're making up. Your court is not my court. The venue was improper. I have an Article 3 court where the hearing has to take place. Period. You have a constitutional duty to uphold that. Now, if you can't deal with the Constitution, all I can deal with is the Constitution.
I'm going to deal with the Constitution. I'm going to follow the procedures that are in here. If you don't want to argue about the motions that's set here before the court, then I can base it on just the argument that I hear from counsel and what I have in documentation now. But I'm going to give you a chance to make your argument here. But it's not your time yet. I understand where you'll be going with it from this, but just be patient, and then you will have a full chance to make your argument.
Okay, what I'm saying to you.
I've heard what you're saying to me, sir.
I'm gonna wait, because I'm in my court.
No, sir, you are in my court
No,
right
I'm
now.
in my
You are in
court
the
always.
King
I'm
County
always in my
Superior
court.
Court,
See, this is the
Department
problem.
43.
This is
and
the
I'm
problem.
not hearing argument from you, sir.
This is the problem.
With this, I'm not.
This is the problem.
There-
Because
there
you're
is
already
no
upset. You're already abandoning your oath of office.
Sir.
Because I'm explaining to you, my court is the
Okay, I'm going to take a 5-minute recess. I'm going to give. You can make whatever argument you want to make, but it is not your time to make that argument yet.
I
In
expect you to
this
know your
courtroom,
right.
you're going to follow the procedure
I
that is set
expect
forth
you
in
to follow
this
your
courtroom. We're going to take a 5-minute
Okay.
recess, and then we'll be back.
Yeah, because you're not going to cheat me out of my stuff. Not like y'all been doing. That's it. This ain't the play.
Back on the record in the matter of Joseph Stanley Piggott, also known as King Abdul Mamin et al. Versus King County et al. Ready to proceed. I'll hear argument from the defendants and move on from there.
Thank you, Your Honor. Samantha Cantor on behalf of the King County defendants, King County Superior Court, and retired Judge Barbara Lindy. I don't have much to add to my written brief, Your Honor. Clearly, this is an issue of res judicata, collateral estoppel. There was an issue decided in another court case. If Mr. Pigot had issue as to jurisdiction, it needed to be raised and addressed in that case. I think it was addressed in that case, but even if it wasn't, it needed to be raised there. It's not the basis to form a new civil suit. Additionally, Judge Lindy and the court and thus the county.
Okay, sir, you're going to have a chance to argue. I'm going to let her finish, and then as far as an argument goes,
He's testifying, Your Honor.
she's not testifying. She's making an argument from what's there. Sir, she can do that, and if you'll have a chance.
She has to take that witness stand.
No, she's making an argument as counsel.
I'm going to use her as a witness because she's providing evidence.
You may continue.
Continue.
Your Honor, both the court and the county, by the actions of Judge Lindy, are entitled to judicial immunity as well for all of Judge Lindy's actions in that prior case. The only thing that I would add to my written arguments is that we find it internally inconsistent that Mr. Pigot has sued in the very court to which he claims does not have jurisdiction. So if he felt that King County Superior Court did not have jurisdiction over him, then he should have chosen a different forum to sue these defendants. It doesn't make sense. And that sort of shows why this entire argument just kind of falls apart. I did receive his written response earlier this week. I would note it was untimely for the record, and so I did not have the opportunity to reply. However, I would also note that I don't believe it raised any issue of material fact that would preclude this court from granting my motion to dismiss under Civil Rule 12b6. So I will rest at that unless the court has any questions.
Okay, thank you. Counsel for Mr. Tracy.
Mr. Your Honor, I also would like to stand upon
I'm up on them. Don't worry.
This is
You know they're about to lose.
R-19
They're scared as hell.
which the plaintiff is suing Mr. Tracy and Ms. Barr. Essentially, what he's claiming is a Consumer Protection Act violation. And the elements of a CPA action, the underlying act is an unfair or deceptive act or practice in the conduct of any trade or commerce. And that's a key portion of it here. And so specifically the elements are to recover under a CPA action. Number one, you have an unfair or deceptive act. Number two, in trade or commerce, and that's an important one, which I'll discuss, impacting the public interest. Number four, and business or property damage. And lastly, number five, caused by the unfair or deceptive act. Now, the issue here, though, is he's suing Mr. Tracy, Attorney Tracy, and Ms. Barr for their legal actions. The fact that they are an opposing party in litigation. Case law states that legal services do not fall within the definition of trade or commerce, except as those services related to the entrepreneurial aspects of the practice of law. And this is not what's going on here. The plaintiff has never been Mr. Tracy's client in any way, shape, or form. There's absolutely zero attorney-client relation between them. Instead, it's purely an adversarial position due to litigation. That doesn't meet the criteria for a CPA action right there. Otherwise, what would happen is every single individual who's an opposing party could sue for a CPA action, which is clearly not the intent of the statute. So, accordingly, he's suing under a cause of action in which he has no claim. And therefore, it is appropriate that it be dismissed under CR 12b6 motion, Your Honor. As the county also indicated, we strongly believe that the plaintiff is collaterally stopped from presenting this motion, and actually this entire case, excuse me. This was raised by the plaintiff in the prior proceeding before Judge Lindy.
Great
my
musician.
understanding that
Baddest.
in his submissions from July 3rd that he acknowledges that as well. And so that was the time to address that issue. And if he disagreed with Judge Lindy's conclusions as to the validity of the treaty and its relation to his case, he could have appealed it, but he chose not to. The whole purpose of collateral estoppel, also known as issue preclusion, is to prevent retrial of one or more of the crucial issues or determinative facts determined in previous litigation. It's supposed to be done to promote judicial economy and to prevent inconveniences or harassment of parties. And that's what's going on here, Your Honor. If you truly strongly felt that that prior proceeding didn't have any authority, he could have appealed it. He chose not to. Instead, he chose to file a case addressing the exact same issue in the exact same court, which, as the county has just indicated, it doesn't make sense. Collateral estoppel does apply here. In order to do so, there are a couple of key elements here. The issue decided in the earlier proceeding was identical to the issue presented in the later proceeding. Well, both of these cases, the key point here is the jurisdiction under the Moorish-American Treaty of Peace and Friendship of 1787. Well, both of cases address that. Prior case ruled not in the plaintiff's favor. He doesn't have the right to now relitigate that very same point. Number two, the earlier proceeding ended in judgment on its merits. Again, it did. Judge Lindy made a ruling. The plaintiff could have appealed, chose not to. Number three, the party against whom collateral estoppel is asserted was a party to or in privity to with a party to the earlier proceeding. Again, the plaintiff was a party in that prior action, and obviously is here as well. So that also is applicable. And lastly, number four, application of collateral estoppel does not work an injustice on the party against whom it is applied. Just as I said, the plaintiff in this proceeding did have that full and fair opportunity to litigate that issue in the prior court proceeding. He chose not to appeal it. That is his prerogative. But he doesn't now get to start a brand new case in the exact same court addressing the exact same issue. That's the whole purpose of collateral estoppel. So, accordingly, this entire case should also be dismissed for collateral estoppel as well, in addition to what I previously argued under the CPA. And lastly, regarding the Moorish-American Treaty, I think Mr. Tracy's briefing succinctly addresses that, and it as to the merits of this so-called treaty. Thank you, Your Honor.
Thank you very much. All right. You said King Abdul Mumin. Now I'm ready to hear from you.
All right. I appreciate you, Your Honor. I would call you Your Honor, but I wouldn't feel like you don't really respect my court.
Well, let me ask one question I have is sometimes in these kind of hearings I'll ask questions as arguments are presented.
Yes, sir.
If Judge Lindy's court, and if you say this court, King County Superior Court, doesn't have jurisdiction over you, why was this matter filed in this court?
Okay, your question is based upon something you're talking about. First off, before you begin to talk to about them and whatever, do you have an answer from them? They need 20 days to respond. I'm motioning for default right now. And you don't have an answer from them, right?
Sir, I'm not entertaining
I'm
the
saying
motion for default
you need
now.
to,
That's something
I'm
that
here,
you have
sir.
to know. But I just asked you a question. You can answer that. You can make your
I
argument.
have a right to motion for default, sir.
You have a right to file a motion for default.
Okay, well, I'll file a motion for default, but at this time, they don't have an answer for you, right? Do you have an answer on the file, sir?
I did not. There was a
Do you
motion
have an
to
answer on the
dismiss
file to my
proceedings.
question?
Sir, I'm not going to argue with you. I want to hear
I'm
your
not
arguments on this case.
You listen to them. I'm talking to you, and now you're playing games. I got the same thing on my response and how you guys play games to hide the truth. And so what I'm saying to you, I'm not here to play like that.
Sir, I'm not here to play games either.
I
I want to hear your argument on this particular issue.
Let me say my claims. I have a federal criminal investigation that's going on against everybody in the whole United States, the whole federal government. being sued. The prosecutor is being sued. Tracy is being sued. Everybody's being sued based upon the fact that they're depriving me of my property and court. And because you don't know about the court of Morocco, you can't really understand what I'm talking about. Because you don't even know what your job is. Okay? You don't have an answer from them, and you're taking their words as valid. Because you have a conflict of interest. And also, my charges are for breach of contract, obstruction of justice, and fraud. That's what this case is about. Okay. Now, for them to bring up other issues outside of what we're talking about, and no answer for this court to proceed on, and you saying like a motion for default. Motions could be made verbally, sir. I do know that. And then when you're telling me that I have to go and put some paperwork in, I've been doing law, I've been into law since 1987, Negro law. So I know about motions. When motions first came up, you had to put everything in writing. Then, in 88, I think, that's when they came up when you can now make verbal motions. Okay. In fact, I think my wife and I created that because of what the court was doing when they stole $58 million, $11,000 from me and my wife. It's the very same court you call fair. This is not a fair court for me. Am I entitled to have due process? Am I entitled to be in my court? See what I'm saying? You don't even know about the court you're supposed to protect. You don't know about the treaty, sir. Do you know about the Treaty of Peace and Friendship, Article 21? I want to hand this evidence into you. That way you can have something as, because you don't know.
Is that, well, if you have it, do you have a copy of it to give to opposing counsel, or at least show it to them?
Opposing counsel has it already.
Okay, but if something's going to be handed up, just make sure that they have a chance to see it.
Okay,
Is it just a copy of the treaty?
yeah, I don't have the full copy. I just got the articles. But this
I've seen it.
Okay.
Okay.
And did you see it?
I haven't seen it.
You haven't seen it. Can I give you a copy, sir? Because this needs to go
Sure,
to
let him see it first, and
Yes, sir.
then,
This ain't the full copy, but this is the one that I gave to the U.S. Attorney, U.S. Court, as well as prosecutors, because they have a problem. The human trafficking. Do you do criminal court?
I do.
Okay, well, you're human trafficking. This is what my case is about. Okay? And so as you're sitting here, I know you're human trafficking. Let me give you a copy of my, so I can show you what you're not supposed to do. This was served upon the court, Western District. I need a copy of that too, so because you've never seen it before. It would be improper for you to make a decision, sir, because you can't understand it. That's what your oath of office is too. That's the supreme law of the land, not just the Constitution we broke.
I've seen this.
Okay, well, you don't, well, okay, well, if you've seen it, then we need to go. My case is about that. My whole case is about that. And it wasn't ever heard in your Judge Lindy's case. Judge Lindy acted like you. I asked her about the Constitution. She didn't know nothing about it. She ran off into her chambers. Just ran off in there and just disrespected me. Okay? She never heard anything. Next thing I know, I'm talking to her about the treaty. She cussed me off and just started dealing with my wife. Ordered everything for her and rolled out. And is that a hearing? I'm still talking to her. And these people don't know what they're talking about. They're witnesses. And you know they're witnesses. So now, as I talk to you about the treaty, give me a copy of that and we can go through it. Because this is a problem.
You can have your copy. You can hand that one back. I'll hand that one back to you.
Okay. Now, this is for the record. This goes in evidence.
Okay. And I can make the copy afterwards, but you can make your argument from that.
No, you can put it in evidence now. Believe me, I have trial skills.
I'm sorry, you have what?
I have trial skills.
Yes, he does.
Well, we're not in a trial.
Oh, every hearing is a trial,
This is
sir.
a summary judgment hearing, so you can make an argument.
Okay. See, this is the problem I have with your court. See, your court, you're already prepared to do your damage to me. I hear your words come straight out. She's going to do a summary judgment. She can't do a summary judgment. I'm going to question these people. I need to call her as a witness as well as me. You don't have no witnesses here? You don't have no evidence, sir? What are you doing?
That's not the purpose of, well, this is not a summary judgment
No,
hearing.
that's what you just called it.
It's a motion under Civil Rule
Come on,
12B,
man.
that it's not one where we call live witnesses.
Come on.
Once you return to council table,
Okay, well,
we'll make our arguments in this
Well, as
case.
soon as I get a copy of that, that's all I was trying to stand here, but I was talking to you, not to waste the court's time. But get right with it. Because you have a treaty that you have proposed. It's the supreme law of the land. It's our civilization. It goes with the U.S. Constitution. And then I'm going to show you why your court is infringing. Not that I don't recognize your court, but that I have a court too.
Okay, you stay back there, you
I'm
make
giving
the,
her a
use the.
I put respect over this. I got you. No, I'll be 65 this year. Okay, I'm not no kid. I know
But,
that.
and let me just tell you,
Yes, sir.
I'm considering what you've written, I've considered what they've written, I've heard their arguments. You can, and I understand generally where you're coming
No,
from
you
with
don't.
this treaty.
No,
But
you don't.
what
You
you've
don't
got
know
to
about it.
address in this hearing, if you want to prevail,
Yes, sir.
are their arguments.
Their arguments?
What they've set forth in their arguments, in their briefs here, those are the issues that are before the court today. So you're calling how you want to argue your case,
All right.
but that's what the court's prepared to address today.
I already have some of the issues up on it. She's talking about the 11th Amendment. The Constitution, she can't even talk about it because she's not a Moor. Okay? Now that's why we need to have this treaty, go through this treaty so you can understand it, because I don't think you know what you're doing in reality. Because if I'm talking to you, I'm not making this up. I'm telling you, this is, we have a treaty between you and I. You're supposed to be friends, sir. And then this prosecutor, who now goes to school of supposed to be learning law, but it's not law, can't use another law outside of the supreme law of the land pursuant to the U.S. Constitution, Article 6, Paragraph 2. And the last sentence, let me read the last sentence to you, because I don't think you know what you're doing. They're using statutes and codes to deprive me of a treaty. And then I'm telling you, I never had a fair hearing over there in Judge Lindsay's. But I'm going to read the full Article 6 to you. And then that way you can understand what I'm talking about. Because you don't play by the rules properly. I can see that already. For real. Because as I talk to you, I'm talking to you about what your job is. Not what her job is. Her job is not to be up here talking to Moore. She can't make a motion against the Moore. Period. This is my land. This is my court. You're in too. So let me read it to you. Article 6 of the U.S. Constitution. It says, all debts contracted and engagements entered into, before the adoption of this Constitution, which means agreements by the states. Okay? They've agreed to this treaty. That means you too. Shall be as valid against the United States as under this Constitution, as under the Confederation. Confederation belongs to the Moors. You owe us money. That's why I'm here. Coming to get my country back and my people. Okay? This ain't about what her motion is dismissed. This ain't about what Judge Lindsay was talking about. She never heard anything. But you're claiming that she heard something. Anybody can be like being signing things, and next thing you know, somebody's talking stuff. Let me read paragraph 2. This is one that's really binding you. Okay? This Constitution, which is your agreement, and the laws of the United States, which shall be made in pursuance thereof, semicolon, and it's going to add some stuff in here. It says, and all treaties made, which you have in your hand, right? You got my treaty?
I've got it right.
Okay. Or which shall be made under the authority of the United States shall be the supreme law of the land. You have the supreme law of the land in your hand. Okay? Are we agreeing that?
Make your argument.
I'm asking you a question,
I'm not
sir.
agreeing that this
No.
is the Supreme
Well,
Court.
what is this supreme law of the
This is
land?
not a chance to
No,
it's
because
not
I'm
your
doing
time to ask
my
questions to the court.
I got
This is
that.
your time, sir. You got a limited amount of time here on this counter.
Okay, I'm doing my best to get across to you, sir, what I need to do, but you're not playing fair. So I'm talking to you court to court. I'm not talking to you from man to man or as over here to like this. We're court to court. This is my court, I'm telling you. You have my treaty. We're supposed to be at peace, but right now you're acting as though we're not at peace. Because the Treaty of Peace in the United States Constitution does not allow you to take anything. It doesn't allow you to do what you're doing. So let me go to this paragraph, this other sentence. And it says it's talking about you and the judges in every state. shall be bound thereby. You're bound by that. Are you or are you not bound by it? I'm talking to you, court to court.
I'm listening to you make your argument.
No, that's not what I'm saying. I'm looking for, see, look, you're trying to make a court order over a court order. That treaty you have is a court order. Look at it, I'm going to show you what I mean after we finish this. Because you're bound by this court order. You think it's a joke. This is my land. I'm fighting for my land. That's his land too. The man right there. Tell him he's not a Moor. Yeah. You stole his land. Your people. Yeah. That's what I'm talking about. This is our land. I'm not here to play with you. You're bound by what I'm talking about. You're in my court. If you don't know nothing about the treaty, and then you're trying to rush me, you need to learn something. Okay, now, and then it goes on to say, anything which is separate words in the Constitution or laws of any state to the contrary, notwithstanding, meaning you can't use statutes and codes against the supreme law of the land. This was written by the Moors, sir. The U.S. Constitution and the Treaty of Peace and Friendship. It's one document. It's not to be separated. Not to be separated. That's why you don't know about it. You've been tricked too. My job is to bring my republic back. Okay? Who stole our country is the Democrats. It's the KKK. That's who you work for. That's why you don't know about this treaty. They told you to take an oath of office, but you don't know what the oath is about. You said you never read the treaty. So how are you going to take an oath, sit there every day, and don't know about the treaty? That's how I know you don't know what you're doing. So as I speak to you, you don't want to answer anything. My job is to tell you about the court that I belong to. Let me finish this here, please. This is it says, this is the certified translation of the treaty with approval by Jefferson and Adams, your people. It says, to all persons to whom these consents shall come or be made known, whereas the United States of America in Congress assembled by their commission bearing date the 12th day of May, 1784, thought proper to constitute John Adams, Benjamin Franklin, and Thomas Jefferson their ministers plenipotentiary, which means they have the rights to negotiate and confer or whatever, given to them, or a majority of them, full powers to confer, treat, and negotiate with the ambassador, minister, or commissioner of His Majesty, the Emperor of Morocco, concerning a treaty of amity and commerce, which means we're supposed to be doing nothing but commerce. You can't even live here, sir. Let me show you what it means. Because you don't want to know about this treaty. You don't really want to know. That's why you don't know. Okay, so we're supposed to be doing business. You can't even do business with me. This ain't business between us. I don't know what this is. So I'm trying to tell you, I know my laws. And then you want to rule for me in my court? You're bound by my court, sir. And after I finish reading this here, you'll see what I mean. Because your people came to my land, stole my land, and then you want to sit here, make up courts, and all of a sudden you big and bad. No, you ain't big and bad, so I'm going to show you why you're not. To make and receive propositions for such treaty, and to conclude and sign the same, transmitting it to the United States and Congress assembled for their final ratification. Congress signed this and hit it. This is the problem. This is what this class action is about. I've got a treason case against Congress. It's not just about y'all. It's Congress, because Congress hid this. This is what I'm prosecuting this case. You don't have no business obstructing my justice. Okay. I'm a federal criminal investigator. I'm the real deal. You want to play like these guys know what they're doing over there. They're crooks. They don't have no rights to even be over here. So anyway, we finish with the commerce part. To making and receive propositions for such treaty, and to conclude and sign the same, transmitting it to the United States and Congress assembled for their final ratification, and by one other commission bearing date the 11th day of March 1785, did further empower the said ministers plenipotentiary, or a majority of them, by writing under the hands and seals, to appoint such agent in the said business as they might think proper, with authority on the directions and instructions of the said ministers to commence and prosecute the said negotiations and conferences for the said treaty, provided that the said treaty should be signed by the said ministers. And whereas, we the said John Adams and Thomas Jefferson, two of the said ministers plenipotentiary, in parentheses it says, the said Benjamin Franklin being absent, parentheses over, by writing under the hand and seal of the said John Adams at London, October the 5th, 1785, and of the said Thomas Jefferson at Paris, October 11th of the same year, did appoint Thomas Barclay, agent in the business aforesaid, giving him the powers therein, which by the said second commission we were authorized to give, and the said Thomas Barclay, in pursuance thereof, hath arranged articles for treaty of amity, which is our friendship we're supposed to be in, but I don't see it. You guys are human trafficking my people. That's what it's about. You can't do it because you don't know about this. It's not your fault. Not your fault, sir. This happened way before you and I were born. But I'm here now. I'm a noble man. I don't come here to lie to you, waste your time. I'm here to protect my dominions. Okay? It says, it did appoint Thomas Barclay, the agent in the business aforesaid, giving him the powers therein, which by the said second commission we were authorized to give, and the said Thomas Barclay, in pursuance thereof, hath arranged articles for a treaty of amity and commerce between the United States of America and His Majesty the Emperor of Morocco, which is separate. We're not the same court. Which articles written in the Arabic language, your Constitution was written in Arabic. It's Muslim law. Everything is written in Muslim law. Okay? Confirmed by His Majesty the Emperor of Morocco and sealed with this royal seal, being translated into the language of the said United States of America, together with the attestations thereto annexed are in the following words, to wit. This is where it comes down to the court order. It says, in the name of Almighty God, this is the treaty of peace and friendship established between us and the United States of America, which is confirmed, in which we have ordered. See, this is a court order. You understand? Okay. To be written in this book and sealed with our royal seal at our court of Morocco. This is where I'm at. I'm in my court, not your court. It might appear to be that way, but I rule. Okay? Now, let me see where we go. And sealed with our royal seal in Morocco on the 25th day of the blessed month of Shaban, which is the month before Ramadan, in the year 1200, trusting in God, it will remain permanent. So is this treaty permanent? Because the United States came here on my land and signed this treaty with my people. That's why you're sitting on the bench. Okay, now let's go to Article 21, because you're listening. I'm close to finishing, because you want to do your job, I want to do my job. Okay. My job is critical, because you brought me here. Let me finish it.
Okay, how much longer do you anticipate?
I'm close to showing you what's happening so you can rule. How about that? Because I'm not giving you no rights to rule on for it then. I'm just saying I know what you want to do anyway. But let me finish this. I'm going to finish that. Okay, this is what I'm talking about. Article 21 of the treaty. It says, if a citizen of the United States shall kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place and equal justice shall be rendered, the counsel assisting at the trial, and if any delinquent shall make his escape, counsel shall not be answerable for him in any manner. So now, I'm counsel. You guys killed my people. This is what my case is about. Y'all kill us left and right and then go to your court and claim it's justified. Now let's go to 14, Article 14. Article 14, it says, the commerce with the United States shall be on the same footing as the commerce with Spain. Okay? Or as that with the most favored nation for the time being. And then it's going to come to you guys. It says, and the citizens shall be respected and esteemed to have full liberty to pass and repass our country and seaports whenever they please without interruption. In other words, you can't live here. You can't have a job here. And you can only pass and repass our country and seaports. Our law is international law. My law is international law. So the way you got it, the way y'all have it, you just cut off the treaty, use the Constitution with statutes and codes, and it's not designed to go like that. This is our will to the promised land. Okay? So you're a United States citizen. I'm a Moor. We're separate. My court is separate. And so as I talk to you, you're bound by this treaty. You have, these are my enemies over here. These are enemies.
Straight enemies.
You're my enemy because you're not understanding what you're bound to. You're in the court, you're King County Superior Court, and you want to rule. It's like you're ruling for yourself. It's like a killer comes and kill your family, and then they're going to come and rule too. This is what I'm saying to you, sir. That's what I mean about the jurisdiction. The jurisdiction is cool. You just don't know what you're doing. You think I'm a regular guy. You come in here, take people, do what you want to do to them, and they don't know what they're talking about, and you just run over them. That's what you do all the time. That's how I was kidnapped by you guys. Human trafficking. You got a gang here. Human trafficking, man. You guys think you're going to go to prison. That's what I'm here. You trying to stop me from sending you to prison? You're going to obstruct my justice, sir? Is that what you're trying to do? Yeah, you're a United States citizen. You can't rule here. I'm an Article 3 judge. I'm from the government, the Republic form of government. Which government do you operate out of, sir?
Now, I did have one question. Why did you file your matter in King County Superior Court?
I told you, my question, because this is my court. Your job is to always use the Treaty of Peace and friendship in every court. Every court. Not come up with some new court. It's telling you right here in Article 6, you're bound by this treaty. I told you I have a court order. This treaty is the court order. The Constitution and the treaty is not separate. Your counsel here has used the 11th Amendment, so she has the rights to use it. She does not have the rights to speak about it. And you considering her argument, this argument's not law. It's not okay. It's not nothing. Anything you put up before me is treason, sir. Anything you do against my court is treason, sir. So you ask me why I didn't appeal? Because Moroccan law is not appealable. It's already court ordered. Let me show you what I'm saying. Let's go to number 3 of the treaty. Because you're not understanding. This is not no game. If either of the parties shall be at war, we at war. Okay? This is real. We hit my treaty. Your people. Congress signed it and they hit it. You know why? You know how they hit it? They started lynching our people. They killed off the Mexicans, my people. Mexican wars the same. Same people, same land. And y'all over here saying, let's send them, let's build a wall. Let's build a wall. We love Trump. You know what I say about Trump? Trump's in the treason. And you see the document I sent to Trump to release my people. Did you see that? Sir?
Sir?
Did you see the United States Court evidence I gave
I saw
you?
the filing that you had.
All right. You seen what I was demanding in my court order. My court order was demanding my people and the truce. Right? Because we're at war. Your court is at war with my people. Your court's stealing my people, sir. Let me show you why you can't steal my people. We finish with number 3 because you want to rush through this. You can't rush through stealing my people. Our people deserve to have the best. I'm the best of the best. 3. If either of the parties shall be at war with any nation, whatever, and take a prize belonging to that nation, and there shall be found on board subjects or effects belonging to either of the parties, the subject shall be set at liberty, and the effects returned to the owners. That's the same thing I'm asking you to give my land back, my people back. I'm telling you, you don't have the rights to do what you're doing right now, so you don't listen to them. But you're doing it because you have a conflict of interest, and you're trying to help somebody who's not even here to say a word, haven't sent an answer in, and you're a court. Come on, man. No disrespect to you, but you're going to have an answer before the court. Okay, so let me say, and there shall be found on board subjects or effects belonging to either of the parties. The subject shall be set at liberty, and the effects returned to the owners, period. And if any goods belonging to any nation, comma, with whom either of the parties shall be at war, and we at war, and you know it, shall be loaded on vessels belonging to the other party, comma, they shall pass free and unmolested without any attempt being made to take or detain them. You guys take and detain my people. Can't do it. I'm so tired of this, man. You don't know what I have to go through. I spent almost 10 years in prison for nothing because of you guys, framing up my people. Made her pay something. She thinks she can try something. You think you can try something? You have a big old conflict, sir. Okay, let me go to number 6. It says, if any more shall bring citizens of the United States or the effects to his majesty, comma, the citizens shall be immediately set at liberty, and the effects restored, comma, and in like manner, if any more is not a subject of these dominions, shall make prize of any of the citizens of America or the effects, and bring them into any of the ports of his majesty in which we own the world, sir. The sun never sets in the Moorish empire. Okay. It shall be immediately released. My people, I'm asking for, demanding that they be released. Okay? As they will then be considered as under His Majesty's protection. I'm in my court. You have my people, and I want them. Okay, almost finished. Number 16. This is when it comes to what you're doing wrong. In case of a war between the parties, comma, the prisoners are not to be made slaves. You guys turned me into a slave. But to be exchanged one for another, comma, captain for captain, comma, officer for officer, and one private man for another, semicolon. And if there shall be prove a deficiency on either side, comma, this shall be made up by a payment of 100 Mexican dollars for each person wanting, semicolon. And it is agreed that all prisoners shall be exchanged in 12 months from the time of their being taken, and that this exchange may be effected by a merchant or any other person authorized by either of the parties. I'm authorized, sir. Now, what I'm saying to you, I sent this demand to Governor Jay Inslee to give my people. It's on my blog. You have the information there where I demanded to turn my people over. This is the same case. This is what I was telling Judge Lindsay about, that she couldn't hear this class action case because she's involved in it. That's the same thing with you, sir. You're taking my people. Can I have my people back? See what I'm saying?
All right.
So now,
You got
I know you got
2 minutes. I've got to give them.
Yeah, I know, but I'm saying to you, you never heard this before, huh?
I've not had anyone argue the treaty
Okay.
for me here.
I never had this opportunity to argue it before. Judge Lindsay, I appreciate you.
Right.
Now, what I'm saying to you, she's claiming I had some kind of hearing. He's claiming I had some kind of hearing. I never had a hearing in my court. She neglected. Judge Lindsay went all around this treaty just to go and do what she did. She couldn't do that. I don't know what her ruling was about. Never talked to her about anything other than I gave her a brief showing her that you guys held me against my will in the King County Jail and others. So now, like I'm saying to you, I have a court order here, sir. You have my people, you have my land, and you're sitting on my bench not knowing what you're doing. So no, she can't talk. She's a citizen. Then she goes and takes the bar, becomes a subject of the crown. You're part of the bar, right? Am I correct? The barman? Okay. No, I'm serious. I'm serious. This is real.
That's not a dialogue here.
No,
So just
this
take
is
your
my
argument.
case.
I got to get to them.
This is my case.
He wanted to argue because I asked him, was he in the bar too? The
all the
judge.
parts play. Because I know how to protect myself. I'm not regular. I'm a king. A king knows how to understand his rules. I know that you don't understand my rules, so it's going to be foreign to you. So I have an order denying this motion. So I kindly respect that you honor my order. Because she has nothing she can write against any order that you have. You're bound by.
So I'll hear from the state again,
Yeah.
if there's any rebuttal or response.
They can't talk. Objection.
Your Honor, the only thing that I would add is that a motion for default would be inappropriate at this time because under the court rules, a filing of a CR 12B motion actually operates just as an answer would, which is to preclude a motion for default. So that's the only thing. I'll rest on my briefs for everything else.
Anything else?
Simply that I agree with what the county just stated. I was going to say the exact same thing, but she didn't give a punch.
All arranged.
Okay, so do I have
Fraud.
any counter against that? Since they
So that they made the motion, they get a chance to do it. So, they get a chance to respond to your argument from there. So, this is a motion before the court under Civil Rule 12. The matter that's before the court here is the complaint that you filed, and you listed as a complaint for breach of contract, obstruction of justice, and for fraud. The two claims that you're pursuing here, the two claims against retired Judge Lindy for negligence, I read that at the beginning, and then there's another claim for unfair business practices against Mr. Tracy and Ms. Winslow Barr.
My claim is
This case arises, as I see it, from the matter before Judge Lindy, which was a dissolution matter under cause number 17-3-05075-3 with a Seattle designation. In that matter, Judge Lindy's findings, she reports that she addressed your issues as to the court's authority and jurisdiction. She indicated that the respondent's oral challenges to the court's authority and jurisdiction to act in that proceeding were overruled, they were not timely and not supported by law and fact. So the sole issues that we're here today is on a motion to dismiss on the pleadings, since they say that you're failing to state a claim upon which relief can be granted here. So let me finish my ruling here, so that we have a clear record, and then if you're unhappy with this, you can appeal it, you can do what you want to do.
My orders are not appealable, so you know.
Okay.
This is what I'm
Well,
saying.
you're
gonna make
your
a
choice.
You gotta rule with the law. See, this
It's
is what I'm saying.
important
Now,
for
what
all
law?
of us. It's
What
important for
law?
all of us here to have a clear
I
record.
wanna ask this question.
Let's not talk over each
I'm
other
not
here.
trying to talk over you. I want to know what law you're using before you make a ruling. Because I don't have no choice but be monopolized by the court, because that's what you are, a monopoly.
I'm a judge sworn to uphold the Constitution of the State of Washington and
The
the
State of
U.S.
Washington.
Constitution. So that's what I'm doing. And let me just, sir,
Okay,
I was considered with you, and I'll
Okay.
let you make your full argument.
all right.
Please be considered
I'm just
here, and then you can take your steps as you want to from this.
Because I don't trust you, man. This is the problem. I can't trust you. You don't know what you're doing. You really don't. You can't do what you're doing.
Sir, can you just be quiet for a moment so I can give you a ruling here? I've been very patient letting you have an argument. I was courteous. I did not interrupt you. Please give me the same courtesy.
All right, sir.
Okay. You may be happy. You may be unhappy with my ruling at the end.
I'm sorry, sir.
Already fixed. I'm whooping
So we
their
are
ass.
here on a motion for, under Civil Rule 12B. Both parties are alleging that you have failed to state a claim upon which relief can be granted here.
Can you explain
As
that?
I'm explaining my ruling as I go through it.
No, I'm saying, what does that mean? So I know what I think it means. Like, your court is different than my court, so I'm trying to find out what she's saying. I never got a chance to find. I know my treaty is a claim. I know my name is a claim. I know this land is mine. I know this court is mine. What is she talking about? I failed to state a claim. I got a contract, a breach of contract. That's what I'm talking about. You have a treaty contract with me. It's a breach. So you want to talk about what you read? I'm not just talking about what you read. You don't even have an answer. So what I'm saying, what is the claim I failed to state? And in what court are you ruling on?
as I look at this matter, Judge Lindy made a ruling on the exact issue that you're presenting before the court here today. So, with that, I'm finding that based on the doctrine of res judicata, that you have failed to state a claim upon which relief can be granted in this particular proceeding. It appears to the court to be the identical issue that was brought to Judge Lindy's attention. Judge Lindy issued a ruling on the merits that I read to you as part of her ruling on the findings of fact and conclusions of law in entering your dissolution. They are here, so really the same parties in interest. In that case, it was Ms. Winslow Barr, and I'm not seeing that a ruling with regard to collateral estoppel works an injustice to you, because you did have the option to appeal this matter up to Division 1. You didn't take that step. It appears your next step was to file this particular matter.
Sir.
Beyond this, I am also finding that under the doctrine of judicial immunity, that a claim could not be brought against Judge Lindy from the beginning, and that you've also failed to state a claim upon which relief can be granted under the Consumer Protection Act, in that Mr. Tracy was not acting in an entrepreneurial way in representing Ms. Winslow Barr.
This isn't the place for you
As to your claims, your arguments there, I listen to you, and I understand that you may have some criminal investigation, but that criminal investigation matter was not something that was set forth at all.
It's right here before you. Don't tell me it's not set
In
here.
your complaint,
My
that is
complaint is
in the
set
complaint that
forth.
was filed under the cause number that's before.
Hold up, man. You're
this
interpreting
court.
it wrong. I didn't ask you to interpret my
issues were addressed.
like that.
You
My
may
issues were
want to make
addressed.
these arguments elsewhere if you've got a criminal investigation pending, if you've got something pending in federal court, but those are not issues
This is
that
called
are
substantive
before
justice.
this court.
You're not going to
If
be
your
fair and
belief
wrong.
is that Judge Lindy did not listen to you at your last hearing, your opportunity to address that issue would have been through an appeal, again, as I said, to Division 1. So
what law
I'm
are
going
you
to grant
bound
the
by,
motion
sir?
of both defendants
What law are you bound by?
to dismiss this case.
Yeah. That's all right. They work for themselves. Anybody that works for themselves, that's not works for themselves, you know it's wrong. Crooks. Yeah, but anyway, I'll be back at you too. Don't worry. This is just the beginning, Your Honor. So-called, Your Honor.
And if, as I said, if you're unhappy
I'm not
with this
gonna appeal
ruling,
nothing,
you're
sir.
more
I
than
got a
welcome to
lawsuit
appeal
for
this
you,
matter
too.
before Division 1.
I've got a lawsuit
of
for
the
you
Court
too.
of
Don't worry.
Appeals. So I've reviewed
Don't
the
worry.
orders
Your court is not my court, sir.
that have been
That's what I'm telling you.
presented,
I have an Article 3 court. You're in the wrong court.
and I've signed them. So
Yeah,
I'm going to
you
hand
signed
out some
something
copies
that
will be
you-
made. If you'd like a copy of these,
You know what I mean?
you can have one to take with you.
It's bound by the Constitution and then goes. You want to show
We'll
me?
be in recess.
Yeah, you can't tell me what you're doing, sir. How you find what you find?
Yeah, these guys have your whole case already figured out for you and place you in a pigeonhole and tell you this is what the case is about. And all the time, you're not even talking about what they're talking about. You hear me, family? These people are so corrupt, man. I'm getting ready to put them all in the guillotine. The guillotine is where these crooks belong to, and you know it. Ain't none of them cool. No lawyer is cool. No of these justices are cool. You have to be a Moor to use the U.S. Constitution and the Treaty of Peace and Friendship. And they've been using our Constitution as theirs for so long as though they own it and wrote it. I showed them that they're not able to use the Treaty of Peace and Friendship. Only nobles can use it. Only nobles can use it. Only a noble or Moor can defeat the Pope. That's what I said. Pope, you ain't shit. Rest of you guys know it too, ain't shit. Queen too. We coming. Reparations. Free our people. Yeah, I'm not playing with none of these crooks. Got them all hemmed up. All in the federal court. Look at that. I ain't playing with none of these fools. Hope y'all know it's a real deal king right here. Everybody else is talking like they're going to do something. Reparations, that's all y'all do is talk and wait for these damn lawyers to do something. These lawyers ain't going to do nothing for you. They're the problem. Whole damn problem is those lawyers. And y'all don't know it yet? Y'all got a guillotine for all these crooked lawyers using these fake law schools they made up for themselves to use them, make a monopoly. Guys got to figure it out. They can't use statutes and codes against the Treaty of Peace and Friendship and the Constitution. It's locked in. It's our will to the promised land. Nobody can enter into your trust like that. United States is in trouble. Human trafficking our people. Look, every time they put up on the caption talking about United States versus the Moor, nobody can put up a case like that against the Moor. United States signed a treaty with the Moors and human trafficking us. I got something for their asses. All of them, all you senators too. Yeah, y'all better get ready. It's Islam.